Good evening, everyone. Will the Standing Committee on Social and Economic Development please come to order? Before the committee can proceed with the business before it, it must elect a chairperson. Are there any nominations? Mr. Isleifson.
I would like to nominate Mr. Mikuleski.
Mr. Mikuleski has been nominated as chairperson. Are there any other nominations? Hearing none, Mr. Mikuleski, please take the chair.
Our next item of business is the election of a vice chairperson. Are there any nominations? Minister Johnson.
I nominate Isleifson.
I understand Minister Isleifson has been nominated. Is there any other nominations? Seeing none, Minister or MLA Isleifson is elected vice chairperson. This meeting has been called to continue consideration of Bill number 35, the Education Administration Amendment Act, Teacher Certification and Professional Conduct. I would like to remind all in attendance of the provisions in our rules regarding the hour of adjournment. A standing committee meeting to consider a bill must not sit past midnight to hear public presentations or to consider clause by clause of a bill except for unanimous consent of the committee. A written submission was received at the end of the last meeting from Christy Frowork, a private citizen. However, it was not distributed before the committee rose. This has now been distributed to committee members. Does the committee agree to have this submission appear in the Hansard transcript for today's meeting? Agreed. Agreed, and so ordered. As public presentations concluded last time this committee met, we will now continue with clause by clause of Bill 35. Does the Honourable Minister responsible for Bill 35 have an opening statement?
I do.
The Honourable Minister of Education.
Thank you, Mr. Chair. I am pleased to be here today for this important stage in considering Bill 35, the Education Administration Amendment Act, Teacher Certification and Professional Conduct. Bill 35 is a historic step towards improving safety for Manitoba students, which the Manitoba government takes very seriously. Given recent examples of serious teacher misconduct in the province, some of which have led to criminal charges for a series of offenses against students, urgent action is needed. In response to these concerns and in discussion with sector stakeholders, Manitoba Education and Early Childhood Learning is enhancing the legislative framework to better protect Manitoba students by preventing and addressing teacher misconduct. This bill was developed through extensive consultation with the sector, including 2 rounds of engagements with education partners between November 2022 and March of 2023. Reflecting what we learned during these consultations, this bill proposes new structures and processes to improve accountability and transparency regarding the regulation of teachers and better align Manitoba's legislation with other Canadian jurisdictions. Specifically, as a result of this bill, an independent commissioner will be established to respond, investigate, and adjudicate matters of teacher misconduct. One of the most significant considerations we heard from stakeholders is the need to have a clear avenue for anyone to make a complaint about teacher misconduct. It is important that such complaints can be easily made after a teacher's first offense in order to ensure that it can be addressed before other students can be harmed. This will also give the Commissioner the ability to identify concerning patterns of behavior and potentially stop them before they escalate. In order to ensure that teachers are not subjected to malicious or false complaints, the Commissioner will have the authority to dismiss a complaint if they consider it to be frivolous or out of scope of their jurisdiction after either a preliminary review or a full investigation. Further, in order to ensure that legitimate complaints can be dealt with in an expedient manner, the Commissioner can enter in a consent resolution agreement with the investigated teacher to resolve the matter or refer matters to be adjudicated by a hearing panel. These amendments also make important improvement to the transparency and accountability associated with the process, including that hearings will be open to the public and their panels will have members of the public that are not and have never been teachers. This will ensure that the public's voice and perspective can be considered given the high level of responsibility entrusted in teachers. Many of the stakeholders that we consulted with during engagement sessions emphasized the importance of public involvement in these matters. To further increase transparency and accountability, consent resolution agreements entered by the Commissioner and decisions from hearing panels will be made public, with exceptions in cases that would cause significant harm to the victims. In such cases, a summary of the agreement or decision may be made public. In addition to addressing matters of misconduct, the Commissioner will also have the authority to take action against a teacher's certificate to address matters of competence. This is consistent with the practice in Ontario and provinces in Western Canada. It also mirrors the scope of the regulatory bodies that oversee other professions in Manitoba. This bill will also ensure a single-door approach for addressing both teacher misconduct and competence matters. In order to guide professional practice and create thresholds for matters of competence, the department will need to first establish professional standards for teacher profession. This is how the definition of competence will be established. Government is aware that establishing professional standards is a very important and complex step in this new framework. Therefore, the department is committed to consulting broadly with stakeholders, including the Manitoba Teacher Society, on the development and implementation of such professional standards before the standards are introduced. Bill 35 will also establish a registry of certified teachers that will be publicly accessible and will provide information on the status of a teacher certificate and a record of actions taken against a teacher certificate. A public registry will increase transparency for employers and parents, providing them the necessary information to make informed decisions. Experts in the area of child protection, such as the Canadian Centre for Child Protection, have recently highlighted the need for such registries in their report, Child Sexual Abuse and Victimization by K-12 School Personnel in Canada. Teacher registries are common across Canada, including all Western provinces and Ontario. Government is committed to respecting the privacy of teachers while also facilitating easier access to this important information. The proposed legislation also provides future avenues to address mandatory training, a certification renewal process that can include obligatory background checks and other requirements to be satisfied at the time of renewal. Other key components of the framework include an expanded definition of professional misconduct and broader reporting obligations for employers of teachers. It is important to note that although the new framework is significantly strengthening government's ability to regulate the profession, it does not erode or reduce the employer's existing responsibilities in overseeing and taking action when they become aware of potential misconduct. Rather, the proposed framework is supplemental to these responsibilities and serves to assess whether a teacher's conduct is unbecoming of a teacher, possibly necessitating action against a teacher's certificate. The department will continue to engage with employers, teachers, students, and other stakeholders, and of course the general public, to clearly communicate and implement these changes. I greatly appreciate the feedback that the committee received from individuals and groups that have taken the time to provide their input to Bill 35. Thank you, merci, and miigwech.
We thank the minister for his opening statement. Does the critic for the official opposition have an opening statement? Mr. Altemeyer.
Well, thank you, Mr. Chair, and thank you, committee members, and I'd like to thank staff as well. Staff who has been here with us since Monday, listening to teachers, listening to presenters, listening to people that had their views expressed during the committee process. It's very important. I did appreciate having a large number of staff here because it signals to me the desire to do this right. And what we heard from a number of presenters was a desire, number one, for child safety. I want to remind committee members and people watching online right now that child safety is a teacher's and everyone that works in schools' #1 concern. Absolutely. Saw that reflected in all of the presentations, Mr. Chair. And it was quite heartening to see that and to hear that. As I mentioned earlier, that it is the #1 piece in the professional code of conduct and professional practice of teachers, and that cannot be overstated. Accountability is absolutely important. People that work in schools understand that without accountability, you can't do your job well. As a former school leader myself and a teacher, a person that was entrusted with kids by the families that were in the community that I served, we took that role very, very seriously. And that is something that will continue. The commissioner's role, Mr. Chair, will be vitally important. It is my hope that the department and the minister consider that the commissioner have some background in education, either through the faculties of education or have extensive experience in working in the system and in working with children as well, and understanding the unique needs of children and how they grow, how they develop. All of that understanding, I think, will be really important for the commissioner to have that. And I'm glad I have the opportunity to put that on the record, because we also heard concerns of the power that the commissioner has in Bill 35. It can't be overstated, but at the same time, it's important, like I said earlier, Mr. Chair, that the commissioner has some experience in schools. The other piece is definitions of significant emotional harm and competency. I did hear the minister in his opening statement say that consultation will continue. I think there is a desire to make this bill the best bill in Canada regarding these particular pieces that are in it. I think there are ways that, like we say, these are living and breathing documents, which means that they can be regularly reviewed and adjusted according to how this plays out in the first couple of years. That part will be important. I also want to remind the committee, too, that we heard a number of presenters say that everyone has a duty to report, not just the people that work in schools. Everybody in the community has a duty to report. I think that's really important. It's an important reminder to us as citizens that that is our role as well, and that can't be overstated either. And also, in closing, I want to thank everybody that made presentations at this stage. Only 2 provinces in Canada have this particular process. This is something that is important, because I believe when we're sitting around here as committee members, engaging in this important process, we're listening to the presenters and taking what they're saying, and we'll bring amendments forward that reflect what was heard at committee, Mr. Chair. I truly believe that. And you will see in the amendments that I will bring forward shortly that they're based on what was heard by the presenters and people that have reached out to myself and to other members in the Manitoba legislature. And with that, Mr. Chair, I conclude my opening remarks.
We thank you, Mr. Altomar, for your opening comments. During the consideration of a bill, the enacting clause and the title are postponed until all other clauses have been considered in their proper order. Also, if there is agreement from the committee, the chair will call clauses in blocks that conform to pages, with the understanding that we will stop at any particular clause or clauses where members may have comments, questions, or amendments to propose. Is that agreed?
Agreed.
Agreed. Shall clauses 1 through 3 pass?
Pass.
Clauses 1 through 3 are accordingly passed. Shall clauses 4 and 5 pass?
No.
I hear a no.
Shall clause 4 pass?
Shall clause 4 pass?
Pass.
Clause 4 is accordingly passed. Shall Clause 5 pass?
No.
I hear a no. The Honourable Minister.
Thank you, Mr. Chair. I move that Clause 5 of the bill be amended by renumbering it as Clause 5.1 and adding the following as Clause 5.2. 5.2, the following is added after subsection 4.1. Consultations, proposed competency regulations for 1.0.1. The minister must consult with, comma, and seek advice and recommendations from, comma, representatives of teachers, comma, employers of teachers, comma, teachers, comma, and any other persons the minister considers appropriate in respect of each proposed regulation under Clause 1C.1. Sounds great.
It has been moved by the Honourable Mr. Iwasko that Clause 5 of the bill be amended by renumbering it as Clause 5(1) and adding the following as Clause 5(2).
We need it read. It has to be read in.
5(2), the following is added after subsection 4(1). Consultations proposed competency regulations 4(1.0.1 . The minister must consult with and seek advice and recommendations from representatives of teachers, employers of teachers, and any other persons the minister considers appropriate in respect of each proposed regulation under Clause 1(C.1). The motion is in order. The floor is open for questions. Mr. Altemeyer.
Thank you, Mr. Chair. Was there consideration in putting a time frame on this particular piece, or is that, was it deemed necessary to have a time frame, or just some of your thoughts around that? I guess, is it every year?
Mr. Altemeyer, on a supplement to your question?
Thank you, Mr. Chair. Specifically, is it once a year, twice a year, 3 times a year? Is there something that you're imagining it to occur like that? Long nights, sorry.
The Honourable Minister.
Thank you, Mr. Chair, and thanks, Mr. Altemeyer, for the question. No, it's basically we'll do it the once before as we sort of roll into actually having those consultations about those regulations.
Is there any further questions? Mr. Altemeyer.
Just clarification, was the minister saying just it's going to happen one time and that's it?
The Honourable Minister.
So initially, when we make the regulations, we'll make sure that we're having those broader consultations, and then after we make the regulations, we'll go out and we'll make sure that we're having those conversations. Then if there's any amendments as we see fit over time, we're able to do that.
Any further questions? Seeing none, is the committee ready for question?
Question.
The question before the committee is as follows.
I need to read it again now. So, shall the amendment pass?
Shall the amendment pass?
Pass.
The amendment is accordingly passed.
Okay, pause for a second. Shall clause.
Okay, shall clause 5 pass as amended?
Pass.
Agreed.
Clause 5.
Clause 5 is accordingly passed as amended. Shall clauses 6 and 7 pass?
Pass.
Clauses 6 and 7 are accordingly passed. Shall clause 8 pass?
No.
I hear a no.
Turn it off for a second.
As is Manitoba practice, if there's multiple sponsors to amendments, we will defer to the minister first,
No, to the bill sponsor.
to the bill sponsor first. My mistake. The Honorable Minister.
Thank you, Mr. Chair. I move that Clause 8 of the bill be amended in the proposed Section 8.22 as follows. A bracket, by renumbering the section as subsection 1 bracket and replacing the section heading with, in quotations, notice of decision, end quotations. B, by adding the following as subsection 2. Exception 8.22 bracket 2, despite subsection 1, information provided to employers or posted on the registry must not include any information that has not been made public under section 8.21.
It has been moved by Honorable Mr. Owasco that Clause 8 of the bill be amended in the proposed Section 8.22 as follows. Bracket A, by renumbering the section as subsection 1 and replacing the section heading with notice of decision. And B, by adding the following as subsection 2, exception 8.22 bracket 2, despite subsection 1, information provided to employers or posted on the registry must not include any information that has not been made public under section 8.21. The motion is in order. The floor is open for questions. Mr. Altamar.
Thank you, Mr. Chair. I'd like to ask the minister, what was the rationale for making this amendment?
The Honourable Minister.
Thank you, Mr. Chair, and thanks to my critic for that question. Basically, this is the first part of the area that we're making this amendment. And because many of the presenters had asked for some of the personal information to be excluded, I am going to also, right after this, be bringing forward additional amendments that will bring even more clarity to the explanation for these.
Is the committee ready for the question? Shall the amendment pass?
Pass.
The amendment is accordingly passed. Shall clause... The Honourable Minister.
Thank you. Chair, I have an additional amendment. I move that Clause 8 of the bill be amended by adding the following after the proposed subsection 8.25, bracket 2, right to appear and be represented. 8.25, bracket 3, the commissioner and the investigated teacher may appear and be represented by counsel or an agent at the hearing, and the panel may have counsel to assist it.
It has been moved by the Honourable Minister, or Mr. Owasco, that Clause 8 of the bill be amended by adding the following after the proposed subsection 8.25, bracket 2. Right to appear and be represented. 8.25, bracket 3. The commissioner and the investigated teacher may appear and be represented by counsel or an agent at the hearing, and the panel may have counsel to assist it. The motion is in order. The floor is open for questions. Seeing, okay, Mr. Altamar.
The clarification question, Mr. Chair. I also have an amendment in that particular clause. Section 8, subsection 25, bracket 3. Do I bring my amendment forward now, or do we have to deal with this? Or do I bring it after we deal with this amendment?
I will, Mr. Altamar, the amendment must proceed on its own. So we will have to deal with this one first before yours. Your amendment, you can ask questions relevant to the amendment that's at the table, relevant to your amendment, though. Mr. Altamar.
Can I ask for leave for a bit of time to consider this a little bit more, because it's quite close to an amendment I'm going to bring. I just need to ensure that I have a little more time to think about it.
Mr. Johnson.
Is it will of the committee to have a 2-minute recess? Is that enough?
Is it the will of the committee to recess for 2 minutes?
Agreed.
Agreed. Committee recess.
Can I do it in 2 minutes?
I'm going too.
I don't think that matters, does it? Hold it for 2 minutes. No, just run her down to 3 minutes. And just let her go. But for a recess, I don't think it matters. So, it might be.
The issue is, can you pass yours, then they're still in the middle of the day, and if the committee is the exact same, if the committee doesn't issue, then they still have to finish off. They didn't get that. Well, so if the member could be. And this, I found this mutual were all in our office, I don't know what this is. But that's Tim, like, that's why actually Christine is here, her job just to advise the chair. Because Sean and Phil are working for the opposite, so she's the neutral party that's gonna help these two. It's a small office, but you know.
It's mighty, it's a mighty office.
Yeah, everybody stays in their lane, so it's just, he has to figure out.
We're back in session. Mr. Altemeyer.
Thank you, Mr. Chair. If I understand this correctly, Mr. Chair, the investigated teacher has the right to be represented by council or whatever representation they decide. Is that correct?
The Minister of Education and Early Childhood Learning.
Correct.
No further question. Is the committee ready for the question? Shall the amendment pass?
Pass.
The amendment is accordingly passed. Shall,
Wait, no, we're going to pause.
the Honourable Minister.
Thank you, Mr. Chair. I have another amendment I'm bringing forward. I move that Clause 8 of the bill be amended in the proposed Section 8.32 as follows. In subsection 2, by striking out subsection 3, so apologize, I'm going to start that over. That Clause 8 of the bill be amended in the proposed Section 8.32 as follows. A, in subsection bracket 2, by by striking out in quotation subsection 3 end quotation and substituting in quotation subsections 3 bracket and 4 bracket end quotations. B, by adding the following after subsection 3. If disability affects capacity to teach, 8.32 bracket 4, if a finding has been made under clause 8.291D, the commissioner, when making information available to the public under subsection 2, must not make available any personal health information as defined in the Personal Health Information Act about the investigated teacher unless the commissioner is satisfied that the public interest in making the information available substantially outweighs the teacher's privacy interests.
It has been moved by the Honorable Mr. Iwasko that Clause 8 of the bill be amended in the proposed Section 8.32 as follows. A bracket in subsection 2 by striking out subsection bracket 3 and substituting subsections bracket 3 and bracket 4. And B, by adding the following after subsection bracket 3. If disability affects capacity to teach, 8.32 bracket 4. If a finding has been made under clause 8.29 bracket 1 bracket D, the commissioner, when making information available to the public under subsection 2, must not make available any personal health information as defined in the Personal Health Information Act about the investigated teacher unless the commissioner is satisfied that the public interest in making the information available substantially outweighs the teacher's privacy interests. The motion is in order. The floor is open for questions. Mr. Altemeyer.
Well, thank you, Mr. Chair. In drafting this amendment, does the minister know that if this reflects current practice in other jurisdictions throughout the country? Is that where it came from, or?
The Honorable Minister.
Thank you, Mr. Chair, and I'd like to thank Mr. Altemeyer for the question. So this amendment is coming forward from the committee presentations, and basically committee personnel that were on the various different presentations were asking for clarity and specifically around personal health information, but it still gives that commissioner that also that little bit of flexibility to be able to, in egregious situations, he or she would weigh that out as far as the teacher's privacy interests on that.
Any further questions? Seeing none, is the committee ready for the question? Shall the amendment pass?
Pass.
The amendment is accordingly passed. The Honorable Minister.
Thank you, Mr. Chair. I have another amendment. I move that Clause 8 of the bill be amended in the proposed Section 8.34 as follows. A, by renumbering the section as subsection 1 and replacing the section heading with quotation, notice of decision, end quotation. B, by adding the following as subsection 2, exception 8.34 bracket 2, despite subsection 1, information provided to employers or posted on the registry must not include any information, A, that has not been made public under section 8.32, or B, about which an order has been under section 8.33, preventing public disclosure.
It has been, sorry. It has been moved by the Honorable Mr. Iwasko that Clause 8 of the bill be amended in the proposed Section 8.34 as follows. Dispense. Is the committee ready for the question?
Question.
Are there any questions?
Sorry.
Are there any?
Mr. Altamar.
Thank you, Mr. Chair. I'd like to ask the minister, does this exist in other jurisdictions in Canada, this particular amendment regarding the double posting of things?
So
Mr. Iwasko.
Thank you, Mr. Chair. So this amendment comes forward again from presentations, but just clarifies the fact that that personal health information that could not be presented earlier cannot then be taken and put on the registry as well.
Any further questions? Seeing none, is the committee ready for the question?
Question.
Shall the amendment pass?
Pass.
The amendment is accordingly passed.
Shall Clause 8 pass?
Shall Clause 8 pass as amended?
Pass.
I hear it.
I hear a no. Mr. Altamar.
Thank you, Mr. Chair. I do have amendment in Section 8.8, subsection 2, subsection A. Moved by myself, that Clause 8 of the bill be amended in the proposed Clause 8. Oh, sorry. Oh, you're handing them out, yeah, okay.
Mr. Altamar.
Thank you, Mr. Chair. I move that Clause 8 of the bill be amended in the proposed Clause 8.8, subsection 2, subsection A, by striking out 4 teachers, 3 of whom, and substituting 10 teachers, 9 of whom.
It has been moved by Mr. Altamar that Clause 8 of the bill be amended in the proposed Clause 8.8 bracket 2 bracket A by striking out 4 teachers, 3 of whom, and substituting 10 teachers, 9 of whom. The motion is in order. The floor is open for questions. Minister Iwasko.
So is this, thank you, Mr. Chair. So to the member, is this, this amendment coming from other jurisdictions or from committee or from where?
Mr. Altamar.
Thank you, Mr. Chair. And in response to Minister Iwasko's question, this is coming not only from committee presentations, but also from the current practice of many other professional bodies that exist in the province, College of Physicians and Surgeons, the lawyers' body, and other professional organizations. It was also mentioned extensively throughout the committee hearing process and would instill, I believe, some parts that the presenters felt was very important to include in the bill.
Is there any, Minister Iwasko?
Thank you, Mr. Chair. So basically just increasing the numbers of teachers in the pool.
Mr. Altimer?
Yes, as it pertains to the same being in other professional bodies, reflecting what already is common practice throughout the province and other professional bodies and organizations when it comes to discipline. Disciplinary panels.
Is there any further questions? Seeing none, is the committee ready for the question?
Question?
Shall the amendment pass?
No.
I hear a no. All those in favor of the amendment, please say aye. Aye. All those opposed, please say nay.
Nay.
In my opinion, the nays have it. Mr. Altimer?
On division.
On division. The amendment is accordingly defeated on division. Mr. Altimer?
Thank you, Mr. Chair. I would like to move further amendments to Clause 8.
Mr. Altimer?
I move that Section 8, subsection 14, bracket 5, the investigated teacher
Sorry,
a-
Mr.
oh,
Mr. Altimer? Mr. Altimer?
Thank you, Mr. Chair. I move that Clause 8 of the bill be amended by adding the following after the proposed subsection 8.14, bracket 4. Teacher may have representation. The investigated teacher has a right to representation in an investigation.
Mr. Altimer, there was a bit of an error.
Yes.
I'll just ask you to read it out again, please.
Thank you, Mr. Chair. Teacher may have representation in Section 8, 14, subsection 5. The investigated teacher has the right to representation in an investigation.
Is there leave to have it the amendment as written in Hansard? Agreed. It has been moved by Mr. Altomar that Clause 8 of the bill be amended by adding the following after the proposed subsection 8.14 bracket 4. Teacher may have representation. 8.14 bracket 5. The investigated teacher has the right to representation in an investigation. The motion is in order. The floor is open for questions. Minister Iwasko.
Thank you, Mr. Chair. And just a question to Mr. Altomar. So, so bringing forward this amendment, have you seen somewhere else in, whether it's Manitoba or other jurisdictions, that have seen that during an investigation, a teacher has a right to representation? Or another body or another person?
Mr. Altomar.
Thank you, Mr. Chair. My understanding of the bill is that once a teacher is starting the investigative process, that they require representation. It was made quite clear during the committee hearings that representation is important, either through council or through the Manitoba Teachers Society.
Minister Iwasko.
From what I understand, that if for this investigation piece, that if a teacher does not want to participate in the investigation piece, that he or she does not have to, so then bringing in representation would be a moot point.
Mr. Altomar.
Thank you, Mr. Chair. I believe it was made quite clear during the committee hearings that teachers feel that they need to have representation every step of the way, because it's difficult to process this when you've been identified as being investigated, that you need to go into it with representation so that you can clearly understand the proceedings as they're moving forward.
Minister Iwasko.
Thank you. So, thanks, Mr. Chair. So, Mr. Altomar, just for clarification, so when we're talking about, you know, earlier on when I brought forward the amendment for, you know, consultation and that, now in your amendment, you're bringing the investigated teacher has a right to representation in an investigation. So, if the commissioner or the panel is investigating the teacher, you're suggesting that somebody can be sitting there answering the questions within the investigation. That's what the representation means, as opposed to somebody sitting and for support next to them.
Mr. Altomar.
In reflecting in my practice when I was working in schools, often when I had to deal with disciplinary processes, the teacher came with representation. Or when they asked for representation, of course, they came.
Minister Iwasko.
So for clarification, during an investigation, there's nothing stopping the member or the teacher that is being investigated of bringing in support with them. It's during the investigation piece that the investigators, whether it's the panel or the commissioner, would be asking the teacher the specific questions. So there's nothing stopping from that, as it's existing, there's somebody being there with them.
So there is somebody.
Yeah, So there's nothing stopping that teacher having support or counsel or an agent with them. It's just that this would be representation in an investigation. This is seeming to be as if that person or support or counsel would be speaking on the teacher's behalf during the investigation.
Mr. Altemer?
Correct. And just in briefly absorbing what was in section 8.25 subsection 3, you know, the previous amendment, I believe that one talked about representation, and this also talks about representation, but really makes it quite clear that representation will be there.
Any further questions? Seeing none, is the committee ready for the question? Shall the amendment pass?
No.
I hear a no. All those in favor of the amendment, please say aye. Aye. All those opposed, please say nay.
Nay.
It is my opinion the nays have it. The amendment is accordingly defeated. Mr. Altemer?
Thank you, Mr. Chair.
Defeated on
On
division.
division.
Mr. Altemer?
Thank you, Mr. Chair. I move that Clause 8 of the bill be amended in the proposed Section 824. To that. I will carry on, Mr. Chair. Okay.
Mr. Altemer?
Thank you, Mr. Chair. I move that Clause 8 of the bill be amended in the proposed Section 824, subsection A, and subsection 1 by striking out 3 and substituting 5. B, and subsection 2 by striking out 1 member of the panel must be a teacher and substituting 3 members of the panel must be teachers. And in C, in subsection 4, by striking out 3 and substituting 5.
I'll once again ask if there's leave, if it can be in Hansard as written. Agreed? It's been moved by Mr. Altemer that Clause 8 of the bill dispense. The motion is in order. The floor is open for questions. Any questions? I see none. Is the committee ready for the question?
Question.
Shall the amendment pass?
No.
I hear a no. All those in favor of the amendment, please say aye. Aye. All those opposed, please say nay.
Nay.
In my opinion, the nays have it. The amendment is accordingly defeated. Mr. Altemer,
Thank you, Mr. Chair. On division.
the motion is defeated on division. Mr. Altemer.
Chair, I have another amendment.
Mr. Altemer.
Yeah.
Because we already passed.
Mr. Altemer.
Thank you, Mr. Chair. This part of what this amendment has already been dealt with earlier by the committee. So, no further amendments.
Is there any further questions on Clause 8? Seeing none, shall Clause 8 pass as amended?
Pass.
Clause 8 is accordingly passed as amended. Shall clauses 9 through 12 pass?
Pass.
Clauses 9 through 12 are accordingly passed. Shall clause 13 pass?
Pass.
Clause 13 is accordingly passed. Shall clauses 14 and 15 pass?
Pass.
Clauses 14 and 15 are accordingly passed. Shall the enacting clause pass?
Pass.
The enacting clause is accordingly passed. Shall the title pass?
Pass.
The title is accordingly passed. Shall the bill be reported?
Agreed.
Agreed, the bill shall,
No, shall it be?
slight correction, shall the bill as amended be reported? Agreed? Agreed, the bill shall be reported as amended. We've had a written submission from Anne Marie Robinson from Stop Educator Child Exploitation. Is there leave to distribute this submission electronically to all members?
Agreed.
Agreed? And number 2, is it the will of the committee for it to appear in tonight's Hansard transcript?
Agreed.
Agreed. This shall be done. The hour being 7:07.
07.
What is the will of the committee?
Rise.
Committee rise.